United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
In case of a fire, please move in a calm and orderly manner to the exits that are pointing through. Thank you. We'll just give a few minutes to set up our Roselle. Just bear with us. Yeah. Okay, we ready to go? Thank you. Sorry for the little wait here. At this time, I would ask for a motion to approve the municipal land use meeting minutes from September 15, 2014. So moved. Second? Second. All in favor?
Aye.
Motion carried. At this, let me just back up just a little bit. The agenda is a little bit different tonight. We have three members of the board that have to recuse themselves at a certain portion of the meeting. So we're trying to get all the business in the beginning of it, and we'll recuse ourselves, and then we'll move on. The members will leave, and then the vice chair will take over. Okay. So there's a little bit of change in our agenda. So for some of the people who come in attendance mostly all the time, just so you understand what's happening. Okay? Thank you. At this time, we have a new application for 325 West Webster Avenue. Mr. Rodriguez, would you please come forward? Yeah, sure. But just make sure the mic's up. No, it's up at the top. Yep. It should be on now. Yeah, it's on. Okay.
Yes, so just to confirm with the clerk that we have the proof of service upon the neighboring property owners and the affidavit of publication. Okay, so the board has jurisdiction to proceed with the application this evening. Mr. Rodriguez, is this Mrs. Rodriguez? Okay, are you both going to be testifying?
Yes.
Okay, you can raise your right hand. Do you swear or affirm the testimony that you're about to give this evening is the truth, the whole truth, and nothing but the truth?
Yes.
And please state your name and address for the record, please, so our stenographer.
Kevin Rodriguez, 325 West Webster Avenue, Roselle Park, New Jersey.
Robert Keegan, 325 West Webster Avenue, Roselle Park, New Jersey.
Okay, the only thing I have to ask you to do is when you speak into the mic. Okay, so just so it records up here. Okay, thank you. I'm sorry. Mr. Rodriguez, please tell us why you're here.
Okay, well, we're applying for a variance. Back in December, we had a new furnace installed into our house. And along with that, a AC condenser for central air. But they told us Walton was the contractor, They told us that we couldn't do it because it violated one of the codes.
We applied for a permit to have the AC condenser placed on the side of the house, but that permit was denied because it's in violation of an ordinance. So we met with Weltman again to talk about other placement options for the condenser.
Yeah, so then when we applied, it was a violation of the ordinance, and then so we decided, you know what, let's just put it in the backyard. They told us that it was only going to be a 3x3 unit, small. It's like, all right, so it's not going to be an eyesore. So in May 10th of this year, when they rolled it in, it was much bigger than what we expected. In the application, we had it handy, a couple pages before the map of where we live. There's a picture of me in the backyard with, sitting next or staying next to the condenser, and that's definitely not 3x3. So I mean, it looks like a unit that you see on top of a factory. So we decided that we were going to apply for the variance to have it installed on the side of the house.
Mr. Rodriguez, what size is that unit? Is that a
It's
3-ton, or is that a 3-ton unit?
It's a 3-ton, yes.
That runs by electric, not gas.
Electric, yes. We measured it, was they're about 4 feet tall. Chest level, I mean, if you look at the picture, you can see it's like right up to my chest.
How narrow is it?
Yeah, it's about 3 feet.
So if you technically put it by the house, when it's sticking out 3 feet?
Now, if you look at the 2 pages later, actually, yeah, 2 pages later, you can see on the side of the house, it's where we were planning on putting it. This page right here, you can see it on the bottom picture. We're planning on putting it right in front of the fencing area, the allowable. So it would be in between that little fence where it jets out and the chimney.
How big is that fence from the sticking out?
That's about a little bit over 3 feet.
Will it fit in that spot? It won't stick out past the fence?
No, it won't. If we line up the condenser unit side by side, like parallel with each other, it won't stick out.
So
it will fit in that space.
It will fit, yeah, it will fit in that space.
So, just from what you just said now, this big baby right here is going to become 2 small ones? Is that it?
No, it's the same unit. It's
Same
going to be the
unit.
same unit, just relocated to that spot.
How big is your neighbor's air conditioner that you put across from?
Much smaller. We looked at that. It looks like it's a little bit lower level, ground-wise, but it's definitely, maybe 3 feet, maybe shorter.
Is that a 3-ton unit on your
I'm
neighbor's?
not sure.
Is it even strictly air conditioner or just heat to also heat pump?
No, just air conditioning.
It's a pretty big unit. Just
It is.
It's quite big.
What brand of
Lennox.
for that model, that's the size for a 3-ton unit?
Yes.
Wow.
Again, before we even saw the unit, they said it was going to be a 3x3 unit. It's like, all right, that's fine.
What did the gentleman come with, tell the contractor when we put it in?
I was in shock because they rolled it in. I'm like, wait a minute, that's not true. The guy that I usually work with that organized everything wasn't there. It was just the guys working it to install. So when I called the gentleman up that had to sign the contract, he actually had to call me back because he wasn't even sure that the unit was the right size, but it turns out
How
that...
many square feet is your house?
I'm sorry?
How many square feet is your house?
The property...
Probably 1,700 square feet, 15. Just 3 tons sounds like a lot of...
I was going to say, I just had one installed and
I don't know, say something about that.
yeah, mine is like your neighbors.
Yeah, it's huge. I mean, it works fine, but
It's an overkill.
Well, yeah, the open
It's
size.
closer to a 4-ton unit.
Yeah,
It looks like.
yeah.
That's what I'm saying, that's why I asked.
I just have a question. If it is approved, would you have any problem putting kind of a tree?
we were actually thinking about either putting in like a little
I got
fence.
it first.
We were thinking about putting like a little
Evergreen, you know,
pink
one of
fence,
the
a braided
huge-
fence, or maybe even like a big bush there.
Yeah, I think bush or huge, you know, it would go a little bit, would look better than another wooden fence. That's only my opinion, but just to kind of cover up, you know, so that is a big deal.
I have a question, Mr. Rodriguez. Your neighbor's unit, that hose that comes out, that's the drainage for the air? What is that hose? I'm just curious.
That's a downspout.
That's a downspout?
Yeah, no, yeah, it's down spot.
Does
yeah.
this whole, does this area in here stay pretty
Dry?
low when it rains or even with air conditioners?
Yeah, no,
in the
it's-
summer, does it kind of
it doesn't
stay
fly.
very moist in that section there?
Yeah, no, it doesn't flood. It doesn't flood at all.
So,
Like
did
if-
you put up the fence?
Did we put up the fence?
No, it was there.
Because I'm looking on your survey thing here, and it's strange. It's not straight,
It's not even.
Yeah, there's a huge tree right
So,
there.
had you put it, that tree is your tree?
I
That tree, I
think
think
so.
is in Maple.
A new tree? But if you had put the fence straight, then that fence would stick out a lot more. I mean, I'm not saying you should change the fence by any means, I'm just looking at that point.
Yeah, no, the fence is a little crooked, but it's because of the tree.
Oh, yeah.
Yeah, I mean, it's possible that the tree's ours.
Is the property line 7.9 feet?
That's what I was looking at.
Yeah, 7.9 feet, yeah.
Okay, so you're actually sticking out a little more than 1.5 feet from the property line,
You're saying
based on the site plan survey.
you have almost 8 feet. That's how,
Yeah.
and this condenser thing is only about 4 feet.
It's 4
3 feet in width, yeah.
3 feet.
But you might want, I think you might.
I'm saying you're shy of
Yeah, it's very small setback.
Yeah.
Yeah, it is.
It's not like- what it basically comes down to. Anybody else have any questions? If we don't have any other questions of the applicant, I would accept oh, I'm sorry. Okay. Sorry, let me back up. At this time, I'd like to have a motion to open the public portion for this application.
Make a motion to open the public portion.
Second?
All in favor? Motion carries. At this time, if there's anyone in the audience who would like to speak on this application, please come forward, state your name and address.
Mr. Chairman, seeing none, I make a motion to close the public portion.
Second?
All in favor?
Aye.
Motion carries. Now, at this time, I would accept the motion to accept or reject this applicant with the,
Have some general conditions.
general conditions of it. One would be putting a tree or a bush or some
Shrubs.
shrubbery to kind of, to hide
There
it.
was actually a privacy screen that was discussed, correct?
Yes.
Yeah, either one, something to, just to soften the look of it, that's all. Because it is quite new.
Yeah, no, we're perfectly fine with that.
And there's any other permits that have to be getting inspections and all that?
Yeah, they'll be in the general
It'll be in
conditions.
Okay, so Mr. Chairman, make a motion to approve the applicant with the stipulation of the conditions that provided, that requested by.
Second.
Any comments? No comments, Madam Clerk, please call the roll.
Mr. Morris?
Yes.
Mr. Malicchio?
Yes.
Mr. Nitschi?
Yes.
Mrs. Kurz?
Yes.
Mr. Stevens?
Yes.
Mr. Costello?
Yes.
Mr. Nichol?
Yes.
Mr. Urbano?
Yes.
Mr. Benmonte?
Yes.
Motion carries. 45 days.
Well, it'll be memorialized at our November 3rd meeting, and then it's 45 days from that, but you'd have to deal with the building department. They could advise you, to do it at your own risk to proceed, but the board doesn't decide that.
I'm sorry, can you just clarify that? So 45 days from when?
Next, November 3rd. When it's memorialized, we have to vote on it again. And basically,
End of December.
and it's published in the papers and all.
End of December.
Right, so it would be beginning of January, basically, is what it would be. The reason for is that anybody can still come forward at that time and say, and come in.
So we can do the work after the end of January.
Yeah, oh, right.
Oh, absolutely. Yes, yes.
Thank you. Good night.
Thank you. Ladies and gentlemen, in your package, you all received some, there was 4 ordinances, and I'd like to work on each ordinance separate. So I'd like to work on ordinance 2419, freestanding banners. Have any comments to send back to council?
I'd like you to look under A. I want to understand what the words are supposed to be because some of it, I think needs to there might be just typos, but you should know about those. So freestanding banners shall be allowed for all businesses. The freestanding banner shall be no greater than 1 foot wide times 8 feet tall, total size above finished grade, and must maintain. It must be maintained?
Yeah, probably.
Yes.
Okay. Must be maintained against the building so as not to impede, not impede. Correct? Okay, so those are the two. Those are the two.
Okay. We'll have the clerk put on hers,
Yeah.
and then she can give it to the borough clerk to make the changes. That's what Any other comments? It was, it must be. Okay, I'll accept a motion to send this back to council with the comments suggested.
Second.
All in favor?
Who moved that? I'm sorry.
Yeah, who moved that?
It was Al.
Al and Glenn?
Oh,
All right, I'll make the motion.
okay.
Frank and Al.
Any assist?
Frank and Al?
Yeah, Frank and Al.
Everybody's going first and second.
I know, I'm
Quickly,
like,
just take care of yourself.
okay.
Okay.
All right.
The second one is 2421, temporary signs. Any comments on that particular ordinance?
Yes. All right, this one I have a little bit of trouble with. Section 1, under sign, temporary shall mean. I'm going to read because you're going to see that it's not a complete sentence. And so if somebody was trying to interpret this ordinance later, I don't know if they would understand how it's to be interpreted. So it says, a sign in place for 45 days or less, which may be constructed of material of a non-permanent nature, such as paper, canvas, or non-durable plastic. A sign of any political, electoral, educational, charitable, philanthropic, civic or religious campaign, drive or event not more than 6 square feet in area and which may be two-sided, provided that such signs are not illuminated and are placed with the property owner's consent and apply with all applicable provisions of this chapter. Where's the action here? I don't get that. What are they saying?
I'll interpret the way I think it is, and this is only my opinion. Is that what they're allowing is the signs to put out in front of your eateries, your sub places, specials, and it's going to be one of them A-frame type,
Yeah.
and it can't be, as it says, any more than 6 square feet. I think the owner's consent, if you are leasing the building from something, then the owner of the building would have to give you the okay they're putting out there in front of your business. I think that's what it's,
It's written as a definition, Diane, so that's what I think your thing is. It's written as a definition.
Okay.
So it says sign temporary shall mean, so it's defining what it
what
is.
it is.
Okay, all right, okay, that I didn't understand. And then they crossed out the election-related signs shall be posted no earlier than 30 days prior to the election and shall be removed no later than 2 days after the election. If that sentence stayed in there, not that I wanted to, but that would mean that the signs could be up for a total of 32 days. Am I right to
Could that's what
think
it used
that,
to be.
okay, no, I don't know, but am I right to assume that now that this 45 days or less means if an election sign goes up, it can be up for 45 days or less total, which means that when the election is over, if it's been up for 45 days, if it's up for 1 day past the 45 days, it's in violation? That's what that means?
No. I think what it is that and again, this is only my opinion, okay, that everything above that particular statement is the 45-day signs. Anything it says in there that's election-related signs, that whole line, 2 lines, 3 lines, is completely out.
I know, but
So the signs can be up, political signs, from my understanding, okay, can be up.
no, because it says electoral. Third sentence down, and it's in bold. It says electoral. So they have lumped that in with all the other signs.
Okay, okay, my oversight on the,
Yeah, we're giving it to Chairman a total of 45 days.
okay, I'm sorry.
I mean, to
I
enforce,
thought they were just taking the whole thing out.
Yeah.
For the,
that's why I'm trying to make sure that we
Okay.
understand, because,
Okay.
because this means that now compliance with this ordinance for political parties is going to be tricky, because if they put the signs up 45 days before, thinking, I mean, somehow that needs to be made clear, or maybe they need to put in that political signs have to be down, I'm just suggesting, they have to be down 7 days after. I mean, if they give them another sentence in there that says, election-related signs shall be removed no later than 7 days after the election, or something like that.
so what, I guess our comment could go back to council is to relook at particular political signs going up, to give some kind of deadline after. After the election, not just the 2 days, so
Yeah, definitely.
I don't want to give them a specific time, let them
No,
figure out what their time is.
yeah.
So we can put that in there as something of that sort, going back to them. How should we go? Carol, you want to just, what we'll do is we'll send it back, I'll have Carol
Explain it.
explain it to how they want it done in there. Okay, so this way, let them pick the time of how long they want the political signs left up after the election.
And then the last thing is that I have a question. This concerns businesses and establishments and all of that, but there are people that put signs in their homes. So I don't know whether we say something about that. I'm looking at the next paragraph down, the posting such temporary signs on fire hydrants, police, telephone poles, utilities, blah, 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 are expressly prohibited. And then it says the sign displayed inside the window of a business establishment to be construed of a non-permanent material shall be permitted, provided that it does not obstruct more than 30% of the window area and is not illuminated. Is there something similar for houses? Can a house put up any size sign that they want in their window for a political electoral sign or a protest sign or whatever, temporary sign?
Good question. I don't have the answer. What we'd have to do is ask to go back to council again and just ask them to look at this program itself.
Just ask about houses.
Houses, homes, homes, what size?
This only addresses business.
Right, that's what I'm saying.
This only
So,
addresses business.
I mean, there might be another ordinance on the books that might
Yeah,
want
that we
to
don't know
address
about.
that, we don't know about. But again, we can ask them, they might come back and just say, is there something else in there?
Those are my comments.
Thank you. Any other comments?
Cover.
At this time, I'll accept a motion to send out to council ordinance 2421 with comments made.
I'll make
Second?
Second.
All in favor? The next ordinance is number 2422, and this is to do with permanent cosmetics makeup salon. Any comments? This is, just my comment, this is not tattooing. This is not a tattoo for tattoo. I couldn't get it out, sorry. That is not permanent. Tattoos are not permanent cosmetic. What they're talking about here is people, when they put their eye makeup type thing on it, or that type of things is permanent cosmetic, permanent cosmetics. That's what that is. That has nothing to do with tattoos. Tattoos are still not allowed.
They do say very
Correctly, it's not in there. This has nothing to do with that. And the reason why I know that is because I questioned it, because I thought if a tattoo was permanent, which it is. But again, this has nothing to do with tattoos. This is permanent cosmetics. Cosmetics.
Question here.
Sure.
That says ear piercing services only? Comes to piercings, just ears?
Well,
Oh,
it's only
Question.
ears, I mean, it's pretty.
Well, it says ear to describe it, it doesn't say, it left it blank, then I would agree that it's left open for interpretation. It says ear, front of it, I think.
I don't know, I'm not. No, no.
No, it's no belly button.
No. It doesn't say that, right?
Should we say that to the mayor and council, though, just that we brought that up as a, because that's a good point. That the ear piercing is for ears only? I think that
Piercing is for ears.
Well, I mean, it's pretty specific. I mean,
Yeah, it says here, please.
It's ears, it's not
There's
ears,
no
it's not
part of the
nose,
body
it's
that
not
you can pierce.
You know, it's body, it's not body.
I think we're gonna leave it at that.
Yeah, I would too.
No, I'm not gonna give you.
Move on.
Okay. Any other, and seeing no comments, send back, accept the motion to send back ordinance 2422 back to council with no comments.
So moved.
Second.
Okay. All in favor? Okay. At this time, we have one more resolution that was put on there on the agenda, and the resolution is to appoint Nicholas Judita III, Esquire, a special conflict counsel for 293 West Clay Avenue zoning appeal.
And Chairman, just so I can explain,
Sure.
with this property, I have a conflict as several of the other board members, so I'm unable ethically to sit on the application. This is to designate Mr. Judita and cover the charge for him being here this evening. He should be coming in a minute now.
Here, he's here.
Oh, I did.
Here.
So that's what the purpose of that resolution is for.
Need a motion?
Yes, I need a motion to accept the...
Need a motion to accept the resolution?
Oh, that's second.
Second. All in favor?
Aye.
Diane.
At this time, I, board member Mr. Glipio, and our council, or board councilor will recuse themselves, and vice chair.
Yeah, we need to take a 5-minute recess.
Yeah, we'll take a 5-minute recess just so we can, have them come up and start, and then they'll listen to the appeal. Okay? Okay. Thank you, ladies and gentlemen.
First, because our meeting has to have a public portion, so anybody can come up from the public and comment. There they come. And so when the gentlemen get back and see, that's what we'll do first, and then when that's done, then we're going to hear your appeal. Okay.
Is there comment for or
It can be for
It is.
everything. Everything. Anything anybody wants to comment on.
including this application? All right. Would it be better than if we hear the application before they comment on it?
Well, there's really not an extensive public comment on this, traditionally like an application. It's a narrow question of whether the zoning officer was correct or not.
Right.
So we can have comments. In other words, the comment section would be after a decision is made. So it probably makes sense to have the comments, we could do them beforehand. That's how we'll do it. So if anyone has any comments on this, they can comment before we hear it.
This is not
That's the way we're doing it.
It's
Yeah.
an appeal. So
Right, but they don't know I don't think the public knows what the decision was and what we're appealing of the decision. Because I don't believe that the appeal papers were made public. We filed them with the,
right, because we're not hearing.
right.
It's not really a variance. I mean, this is not about whether it's, if there was a variance, we'd have questions of witnesses, we'd have cross-examination, we'd have comments at the end. This is an appeal from a zoning officer's decision, so it's a very narrow question as to whether the zoning officer's appeal should be upheld or not. So in that sense, it's not like a typical variance where you're going to have extensive question period, then a comment period at the very end. So we've chosen to have the public comment section in advance, so anyone that's here that wants to speak about it can. But the decision as to whether the zoning officer was correct really has nothing to do with public comment, because we know what the zoning officer is going to testify about what was presented to her. You're obviously free to have anyone you like, particularly the person that I suppose spoke with her, testify about what was said. And then this board will make a very narrow decision whether the zoning officer was correct or not.
Before we begin, though, let's just make sure everybody knows who's up here and sitting for this. We are acting as a zoning board right now when it comes to your appeal. And so the people that are here for Angela, for your, now let me just see if I get everybody right. I'm going to start from there and go around for you, okay? Scott Nickel, Al Nitschke, Len Costello, Diane Kurz, Jay Rapino, Paul Vimonte, and John Stephen. And our attorney is Nick Giuditta, Giuditta. All right, so do I have a motion to open up the public portion?
So moved.
Second.
Oh, what do I do with this? We'll open up the public portion. Anybody who wishes to speak on anything, would you please come forward? And I guess the best place to do it would maybe be right next to Angela. Just make sure that that is on. Good evening.
Ladies and gentlemen in the audience, viewing audience, members of the board, good evening. My name is Jacob McGarrett, 612 Sheridan Avenue, Roselle Park. Can you give me a synopsis of what this meeting is all about, for the record?
It is our monthly meeting where we hear whatever has come before our board. So tonight we had a person wanting to move their air conditioning unit. We heard that. And then we had 3 resolutions that the Borough Council would like us to put our comments on, and we did that. And now we're going to be hearing an appeal for a waiver for site plan approval.
These folks are for what? Why are they here?
Okay, do you want to should I explain? Sure. Okay, all right. The property is, and you'll please correct me if I get any of this wrong. The property is 293 West Clay Avenue. There are new tenants. In order to be able to be in a building and use that building, you have to have a certificate of occupancy. If you don't have a certificate of occupancy, you can't be in it. So how do you get that? One of 2 ways. You either have to apply for a site plan review, or you have to apply for a waiver of a site plan review. Now, one of the reasons you would need a site plan review is if it's a use that is not in the zoning. So, in other words, this particular applicant is a church, and that use is okay to use in this business zone. It's the neighborhood business district. So they don't have to submit a site plan for us to review, but they do have to submit a waiver of a site plan because we have to know who's going in there so that we know if they are abiding by our zoning regulations. So when the church applied for the waiver of site plan review for a change of tenancy is what it's called, our zoning officer reviewed their application and denied it because of lack of parking. And so they then have the opportunity to appeal that decision, and that is what they're doing tonight. And so we will then hear what our zoning officer says about how she made her decision. We will hear what they have to say about why they think that the appeal should be in their favor, and then the board will discuss it and decide. And then after that, whatever other options are available to them, or whatever happens, is the next step, but it's not now. This is just one thing right now.
Thank you. Good evening.
Is there anyone else wishing to speak? Please come forward. Okay, if there is no other public comment, may I entertain a motion to close the public portion?
So moved.
Second.
And all those in favor?
Aye.
So now we welcome you to us, and could you please, I think you know what you're supposed to do. So I'll let you take it from here.
Good evening, everyone. My name is William Courtney, and I represent the Heart of Worship Church. And I have sitting beside me Pastor Desmond Yarborough, who's the pastor for the church. And we're here today to appeal the decision of the zoning officer when she denied the waiver site plan approval. So my understanding from what you just said, she's going to go first and say why she.
I'm not sure whether, how would...
No, the applicant is appealing, so he should be given the opportunity to go first as an, we call it an appellant.
Thank you.
Yeah.
Yes, I mean, it's accurate that when the church first came to the township for the waiver site plan approval, they went and they started an application. There was Mr. Kelly, he's here this evening, that went to ask for a waiver of site plan. That waiver of site plan application is contained in our submission, our revised submission under Exhibit D, and he put the address of the location. What apparently was the confusion was that the church isn't renting the entire building; it's renting a portion of the building, which is approximately 1,600 square feet of the building. When they didn't hear anything after several weeks, apparently the denial went out, they didn't receive it, they came back, and I went with them. And we tried to explain that, because it came up in the discussion that this letter went out, and there was a parking problem. And we said that, well, we had looked at the ordinance, and the ordinance said, because it was a church and it didn't fit into any of the categories that are laid out in the ordinance, then it collapses into the catch-all, one space for every 250 square feet. And when you add up the square feet, they needed 6-point-something spaces, which we called 7. And they have 7 spaces. As a matter of fact, they have 8 spaces. They have 8 spaces. We also included in the submission the document from the borough zone expert on the property when we were dealing with another tenant on the property, and the borough said there's 8 spaces there at that property. So there's no one else in the building. Yes, the building is 3,100 square feet, but there's no other tenant in the building, and there will be no other tenant in the building unless an appropriate application is made to this board. But right now, there's 1,600 square feet, and they're using those spaces, and we have plenty of space for those at 1,600 square feet. There's no alteration to the outside of the building, nothing being done to change the building, and all of the requirements that are set forth in the ordinance that says construction code official may waive the site plan review and approve and approval for alterations to existing buildings where the alterations will not change the exterior of the building dimension. Well, first of all, we're not doing any alterations. The use is permitted, which it is, and the alterations will not increase the parking requirements, which there are no alterations to the existing parking requirements. So it doesn't violate that section. And given the fact that I think the denial was clear that it was denied for parking. Looking at the borough's own expert, who says there's 8 spaces there, and that's what we were told. There's 8 spaces. They only need 7. And so the denial for parking reasons really is not a valid denial. Now, we understand that when the zoning officer denied that, she was unaware that they were only renting 1,600 square feet. But when we came back, we sent a letter. I sent a copy of the expert report showing that there was 8 spaces. And I sent a copy of the lease showing they were only renting 1,600 square feet. I asked for reconsideration, but the response was basically, we've appealed, so this is our remedy to come to you. So they didn't reconsider once we did that, so we're asking you to reconsider this, given the fact that it really is only 1,600 square feet. We meet the parking requirement based upon the borough's own experts, and there's no alterations to the building, and it's permitted use. So we don't believe we need any type of variance at this point. We want this body to look at this for what it is, and we ask that you grant us the waiver of site plan.
Okay, thank you, Mr.
Thank you.
Courtney. Now, will we have our Senate members?
Yes, do you have, you don't have anyone wants, do you have anyone who wants to testify as to what happened in the conversation with the zoning officer, or what was said sufficient?
Well, unless the zoning officer is going to say something else happened, I don't think there's any dispute as to what happened, really. And then I can have Mr. Kelly come up and
No, it's up to
he
you.
can tell, if you want to hear from Mr. Kelly what happened. But I don't think there's any argument here as to what occurred.
Oh, we just want to make sure you have every opportunity. We don't want to, anything you
Well,
want to say to
I'll-
us, we want to hear.
I would,
You can reserve your right.
I will reserve my right to
Okay.
put some witnesses on if there's conflict in what,
Okay,
and what the zoning.
good, okay. All right, Mrs. Negro, would you please come forward? That's great. That's great. You need to be sworn. Or, Angela, you want to do it?
Oh, I'm sorry, that's the same. Sorry. No, I'm fine. Would you raise your hand, please? You swear to testify about to this matter for the truth and the truth.
Yes. Please state your name, and does she need to put her address in, or does she just need to put her title?
I'll just use the title.
Yeah, your name and title, and then just do that first.
Lynn Venera, Roselle Park Zoning Office.
You need to speak closer to the
This
microphone.
address here.
And we use this address, okay. All right, so, would you like to tell us, Mrs. Vinegar?
Sure. I did, like he said, I did get the application, and I did have to look at the entire building. And the entire building is about 3,100 square feet. And they need about, I think it was 13 spots for that.
Yes.
13 spots for that. I realize it's, they may be using half, but we can't actually go by that. We have to go by the whole building, because you can't leave no parking for the rest of the building. So that is why my decision stands.
That's why you made that decision.
Correct.
Okay, so, do you have any questions for her, Mr. Burke?
Well, yes, this is because I haven't heard this. Ms. Vinegra, you're saying that you cannot take into account that the landlord is leasing just 1,600 square feet, so the building can house somebody.
Right, but you would need basically a variance.
I understand what you're saying. If they were renting for 3,100, the entire
Well,
building.
you need to take into account the whole building.
I understand
Yeah.
what you're saying. I mean, I'm not aware of any ordinance that says that. So you're telling me you have to take it into consideration, because if you have to take it into consideration, you're saying that these people, that the building couldn't be leased unless it had 13 spots.
Well, you would have to go for a variance.
Or you would have to go for,
I can't say because I don't know how that would play out.
and according to your expert, it only has 8 spots.
Oh,
Correct.
wait a minute, she can't testify to that. Okay. I better interject here, Mr. Brady, and set the record straight for this. I would like to bring everyone's attention to that Exhibit H. I just want to clear this up because I don't want it to be relied upon and not be correct. I'm so sorry. If you look at this, it was a letter from our planner to the Municipal Land Use Board, and it was in regards to the previous applicant. And on page 2 of 3, he does talk about the B1 Neighborhood Business District, and he says parking, 3,100 square feet building. And then he based that 8 spaces on 200 square feet, not 250. However, when we were hearing that application, and you weren't here so you wouldn't know, when we were hearing that application, we as a board questioned him. And we said, well, how did you come up with that? How is that set in stone? He goes, well, no. I was just using that as a rough estimate to be able to figure out approximately, but there'd have to be a specific parking plan in place that shows exactly these spaces. And he made that very clear when he testified to us for that. So I didn't want you to rely on that when it's really, you're looking for 250 square feet, this is 200 square feet, plus it wasn't an official letter to anyone but us for our purposes it wasn't meant to be set in stone. And you can go back to this transcripts and you can hear what he said.
If I think I would imagine that they're available because apparently the board has read the transcripts.
I mean, I chaired the meeting, I remember.
Okay. So when we were given this document, okay, we were told that there were only 8 spaces, but that we'll have 200 square feet per space. Okay? They only needed 1 space for 250 square feet. Okay, they needed 1 space for 200 square feet for that use. They need less spaces as a church. So,
I know, I just wanted to make sure
I
that was understood, but in nowhere are there any spaces yet. I mean, we're talking about something that's made up. We're just saying there's that many spaces because somebody measured. There's no official survey, there's no parking plan, there's no engineer's drawings, there's no lines, there's no handicap, there's no nothing.
well,
So you're asking, sort of parking because
well,
that's
somebody
right.
then made a determination that there's not enough parking. Who made that determination?
Our zoning officer did based on 3,100 square feet.
I just didn't look at the lighting, and there's just no way.
Well, we don't know that. We'd have to have an engineer.
I'm sorry.
There's actually been no one. I mean, we got to note that there's not insufficient parking, and she's saying for 3,100 square feet. We're not leasing 3,100 square feet, and we're not, and we'll make the representation that nothing else would be leased in that building unless we came before this board for a variance. Nobody is saying that we're going to turn around and lease that. Believe me, if we turn around and try to lease that other square footage tomorrow, we all know we're going to have to come back here or comply with the laws that are in effect at the time in order to get that space leased. No one is talking about leasing anything other than the 1,600 square foot of the building.
Mr. Courtney, are you talking as the attorney for the church or as the attorney for the landlord now?
For the church.
Well, the church doesn't have the right to say who the landlord can rent to.
Well, the church, the landlord and the church have an agreement that he's not going to lease to anybody
Where
else.
is that? Is that in writing somewhere?
Well, I don't think it's in writing, but they put it in writing. They do have an agreement that he's only going to lease the 1,600 square feet. That's the only part of the building that's going to be leased. And if anything else is going to be leased, they would have to put an option to it. And they have to come in and comply with all the laws.
Well, actually, anybody, if he, let's just say that you did that, and he would say, but I want to lease to somebody, then that new tenant would have to come before us.
That definitely would have to come before you, and if they comply with all the regulations that they would have to comply with. We're not saying that this is any different, and that we would try to do something, try to backdoor this. We're just trying to come in and say, these people are only leasing this part, and there's sufficient parking for these people to come in.
Oh, gosh, you have no idea. I sit on this board as a volunteer. I'm not speaking for everyone else, but maybe they would agree with me. We want this town to succeed. We want this to work if it can. So we are always looking at things, not how can we shoot it down, but how can we make it work.
Well, we're trying very hard to make this work. I have a photograph here of when they had their service after we got the board permitting them to have their services. If you went through that tunnel, okay, I gave you the other side, and we took a picture of the other side of that tunnel when they were having their service on Sunday morning. No one's on the street, no one's parked there. There was plenty of parking in the front of the building and down the side streets. I mean, there was no problem with parking. And this is where the bulk of the use of this church is. This is not Sunday morning.
So, Mr. Courtney, the church knows that the amount of spaces that they have to have are 7. And they know that are 7, right? And they know that 7 spaces will fit there. As a board member, I take this very seriously. So I like to go to the sites and see what's there. And so I have been there 3 times. One time, I was very impressed. It was a Sunday, and there were 2 young men outside, and they were making sure that no more than 7 cars were in that parking lot. And I thought, this is a church that's trying to help and abide by our rules and regulations, and this is a good thing. The last 2 times I was there, the one time was a Friday evening, and there were 10 cars in the lot, and the second time, it was Sunday, and there were 11 cars in the lot. If you know you're only supposed to have 7 cars in that lot, why were there more? In addition, part of our ordinances, if you want to follow our ordinances, say that there's no parking on gravel, and behind the building is gravel. It is not a paved parking lot. It is not a place where cars should be. I'm just, you know, we want to be as good as we can to you. By the same token, we have to go one step at a time here, because and the step right now is that this application for this waiver of site plan review for a change in tenancy has a couple of things on it that are questionable to me, and I will tell you what they are, but it's not my job to say yes or no to this. They're small points, because I guess, I don't know if you could tell, but I'm kind of picky. So the one says the present or prior use of these premises as a community center. In fact, that is incorrect. It was not. It was an illegal fitness center, gym. And before that, it was not a community center either. So I don't know where community center came from. And also the gentleman that signed this was a managing partner of Visionary Partners. And I nowhere in the incorporation papers could see where he was given the authority to do this. So my question, was this even legally authority? But that's neither here nor there now, because we're at this point. Because we did ask for when you did appeal, we did ask for, where our ordinance says that you have to provide the appeal on your letterhead, and at that point then, Reverend, you signed, Pastor signed the documents then. However, it does not say 1,600 square feet on this. So within the four corners of this document, we have a zoning officer who said, and I think if you look in our off-street parking, there is a place there, and I can tell you where it is, that says that would maybe back up why she did that. I can't speak for her, but when I was trying to figure it out, if you go to our ordinance and you look at our off-street parking and you look under O, it says the required parking spaces for a multiple-use building may be provided collectively, provided that the total of such facilities shall not be less than the sum of the requirements for the individual uses. So that means 3,100 square feet to me. And maybe it's interpreted differently by somebody else. So basically, that's simply what we're trying to do, is to say, does our board agree with what our zoning officer did based on this? If we say we agree with her, then you have options. We don't want you to go away. We'd like it to be done correctly and properly. So,
and we want to do it correctly and properly, and that's what we were trying to do when we gave the additional information within a week after that first application was made, to show the lease, to show the square footage, to show the prior report about the parking, to see if we can get that information to her and to whatever people had to see this, so we can expedite this. But we were told no. We had to wait until the 20th. That's what they forced us to go into court to get an order, so they can have their services until we can get this resolved. And we want to resolve it. We want to comply with what has to be done.
and it was my understanding that the services were supposed to be for Sundays.
Yes.
So then what was going on the other days of the week?
Well, it wasn't, the use wasn't limited to Sunday.
Okay.
Okay,
Maybe I got bad information.
Well, no, it was not limited at all anyway. We were able to use the building.
Without a CO, without any of the inspections or anything that makes it safe for you guys to be in there.
Right.
You did what?
The Superior Court judge agreed with it. Well, actually, the borough agreed, consented to it until we came and heard this appeal. Now, after tonight, that consent order is now void. Okay, if you don't grant their ability to the way the site plan approval, we have to now go back into court and continue this litigation. The judge will decide our application for restraints until the entire lawsuit is resolved, which could, theoretically take years. But we don't want to do that. What we want to do is we want to do what you want us to do in order for these people to have their church. They don't want to do anything wrong. They want to comply, and they want to be treated like everybody else. The Delegate Festin next door. I mean, they have the same parking lot we have. And if you want to look at parking, I mean, they have a hall there. Sometimes they fit 20 cars into that park, all packed in. I mean, and it happens on a regular basis. The dance hall next door, I think they have, what, 4 spots? One night we were there, I mean, the place was packed with probably 30, 40 people. They don't have parking. The deli doesn't have parking, but the church, okay, is just being told, hey, how come you can't park on that gravel? And you
Oh,
can't.
because it's in our ordinance.
I understand. And in your ordinance, when you have, I mean, we have the next door parking lot that they told this board that they had overflow parking at the church. Apparently, they don't have overflow parking at the church. Nobody has overflow parking. And neither does the dance hall. But they all operate, the police don't come to
Okay,
their...
Mr. Courtney, I'm going to stop you. They are not on trial.
I understand. I was on trial either.
It's, I mean,
But-
you're saying things that you're not substantiating with you know, things that we can, you're just telling us. You know,
I'm just trying to figure out what we need to do.
You
to
need
be like
to-
everyone else.
Okay, you need to, well, because you're thinking, is what you're saying, that we're not treating them fairly, and so therefore you're not treating, you need to be treated like them?
No. I want to, all they want is they want to have their church, and they want to have, they're in a building of 1,600 square feet. If there is a waiver of site plan, then there is really no requirement that they have to paint these lines on the ground.
Well, there is a requirement for handicap,
Well,
and there is a requirement that you can't be on the stone. And you really need to show us, I mean, I think we do have a requirement, wait a minute, I'm going to look that up, because I think we do have a requirement to have the spaces, I know I'm just reading it somewhere. No, I remember reading somewhere.
I think, Counselor, if you look at Roselle Park Ordinance 40-2803T, one of the questions that comes to my mind is whether the zoning officer had before her a site plan that showed 8 conforming spots could be located there, because the ordinance requires different standards in terms of aisle width or dimensions depending on how the parking is angled. I think that's kind of the threshold question.
but this was a waiver of site plan application.
Right.
So you're saying they needed the site plan to get a waiver of the site plan?
Well, in order for her to decide whether there was sufficient parking there that would allow a waiver of the site plan, I would think one of the things that could have been done was to have shown that the site plan had conforming number of parking spots. I think that's what the chairwoman is trying to get at when you look at the ordinance.
And
You can't waive the site plan unless you know, A, the correct number of spots, and B, whether they conform to aisle width pursuant to the ordinance. That's the applicant's burden before the zoning officer when they seek a waiver of a site plan in this kind of situation. And that's really the point that I think she's trying to make.
I mean, again, what we want to do is we want to, if the problem is that the gravel is in the back, we'll pay for that, and we'll make it so there's no gravel.
But I think there's an easement from the railroad back there. I don't think you can. We have to research that.
There's no easement, the easement from there's no easement, and again, I've looked at this property for years, okay? There's no defined space on those deeds where that easement goes. We agree that there's a right of egress and...
No, different easement I'm talking about. It's a pipe. It's not underneath it's not the path.
The pipe, I believe, is on the other side of the parking lot, on the Diorian side. It's not on West Place side. The pipe is on the other side. And the pipe, okay, if it goes parallel with the railroad tracks, it's on the deli side also, and that's paid for.
But, sir, why can't you show us this in black and white? Why do we have to have this back and forth with you're telling me, and so we just go, oh, okay. I mean, because there's too many, we have to think forward and say, in the future, what's going to happen for the town when this changes? When something happens, what do we have to rely upon? And right now, it's just you telling us, oh, no, there's...
Well, I'm just trying to answer your
There's
question.
enough.
I didn't know this was even an issue until you said about the pipe. I mean, and so I'm trying to respond on the cuff here.
Oh, I meant the parking spaces as well, yeah.
Excuse me?
I meant the parking spaces as well.
You want to know how many spots are there?
I want to know where they are. You see, this is a little different than a regular parking lot because it has pedestrian traffic going through it.
I understand.
So we have to be very careful because we have our school kids going through there. And there's quite a few people that use it. So this is makes this a little bit of a higher threshold because we do have the public safety to think about as well.
Right, and that was an issue several years ago when we suggested that we had engineers draw alternate routes for that walkway where the children weren't walking between cars, and we were told by the town that they didn't want to consider moving that walkway. Because
Maybe it's time to consider it.
I think it is. I think we would love to move this walkway because there'd be no question as to where the spots would go and how it would work. But right now, I can show a picture if you would like. I could show it to all of you of 7 cars parked on that
I've seen 11.
I can show 7 cars, not over the walkway, perfectly lined up in that block. And on the same day, the other side with 20 cars in it, okay? All parked all over.
Sir, I will not allow that. I just will not.
How about ours?
Yours we'll talk about.
Okay. I mean, we can show, I would like to submit this so you can see how neatly 7 cars can fit into this spot.
Sure,
Yeah.
please do. You want to-
Well, we can make it an exhibit, but with the understanding that, again, the only evidence that is before this board is the file materials of the zoning officer. So you can admit it, but it's not really something that they can rely on.
So the zoning, what we were asked to do on this appeal was submit all of our documents again in an amended application. We did that, which includes much more than we submitted.
Well, it was an amended appeal, not an amended application.
It was amended appeal.
Yes, yes.
So we gave you the information, and the board does have that information. Okay, I'm going to show, can we ask the court reporter to mark the photograph? Yes.
I think so. So this is what. Does any of our board members have any questions or comments? Okay. No, we're not yet, we're just, does anybody would like to see this work in a lab? See, it's really not an issue of whether you have the correct parking spaces or not. It's an issue of, did she make a mistake on the waiver and approve something she shouldn't have? And based on the information that she had, at the time when she made the decision, she had to work with that information. She had insufficient information. So then that allows you to say, okay, you were denied, now you appeal. And now you're saying, now we've given you sufficient, in your opinion, sufficient information. And now our board has to decide whether that is enough to say that her decision was wrong.
And when we were, and I will ask Mr. Kelly to provide some testimony here, but the waiver of site plan application, which is on Exhibit B, that he did fill out that, and he went there and he did speak the zoning officer, and there was no discussion of how many square feet he was renting from the building, what, was he renting the whole thing? They didn't ask to see the contract. There was no question there of if he was renting the whole building or part of it.
If there was something, she wouldn't have thought of that, why would she have thought of that? You
I know.
Would have been something.
But when he built, there's no part of the application either that even asked, he's running the whole building or part of it, or what's the square footage? Because when you apply the parking regulations, it deals with square footage. I mean, then that should be on the application. Because if you have to go through a calculation on parking and square footage, you should know how much square footage. That wasn't on the application. So that's
unfortunate, yes.
That's going to save us a lot of time. But he did fill out what he was supposed to fill out. And as soon as we realized it was an issue, we gave the additional information and asked the zoning officer to consider. I don't see why that consideration should be granted because it seemed inappropriate for the zoning officer to say, okay, now I have more information, now I'll look at it again. But again, we're here a month later, and our real concern here is that unless something is done, we're going to be forced to go back to the court to try to keep the doors open, to try to keep this church going, unless this board gives us some kind of at least temporary CFO or grants us some temporary relief until we can get done what you want us to do.
I wish we could do that, but we are not, that's not our function. Okay, so what you're saying, Mr. Horton, is that the information that you have given us in your exhibits A through H, in your opinion, are satisfactory for us to be able to say that, yes, it does meet the 6.4 round up to 7 parking spaces in that. We should say that our zoning officer was incorrect, and once we say that, then you will be able to have your certificate of occupancy. Is that what you're saying?
Well, I do think that is good enough. I do want to put some I want to make the record that Mr. Kelly, what happened to Mr. Kelly is what occurred to the zoning officer. Again,
No, we don't care.
we're not doing this to say that the zoning officer did anything improper here. I think we think it was a misunderstanding all along. And given the fact that the forms that she had didn't ask these questions, that's probably why this happened. We don't think that the zoning officer was doing anything wrong. In fact, we're trying to correct it. What we would like to do is we wanted to get the application right. And we think we provided the zoning officer and this body and the borough with plenty of information to look at this and let this church continue to operate. And if it is, there is a problem because there has been nothing other than the zoning officer saying there's a parking problem, and that, from what our understanding was speaking to the zoning officer, didn't come from her, it came from some other department. It came from construction officials. Because there's a problem with parking, we don't want that problem. And that's how the parking issue came up. The zoning officer didn't do anything on his own. He was told that by someone.
Do you want to do your testimony thing?
Sure.
Sure.
Mr. Kelly? Where would you Mr. Kelly says.
Hello, Mr. Campbell. Would you please state your name and address, please, into the microphone, and then do you need to be participating?
No, we can swear you in, sir, please.
Mr. Kelly, raise your hand, please. Do you swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth? You can just give your address for that.
Okay, Boston Bob, Broadway, Stephen Brady, Long Branch, New Jersey, 07740.
Can we be seated?
Oh, yes, please, yeah, just speak into the microphone, please.
Mr. Kelly, I'm going to show you a document that was submitted to the board on October 7th. And in that document, there was an Exhibit B, which is was a waiver site plan review for a change of tenancy. You ever seen that document before?
Yes.
And did you fill that document out? Did you go to the zoning officer on 8/26/14 and ask for a waiver of site plan review for change of application? And who do you work with? Okay, and do you work for them individually or through another company?
I own Vision Apartments, and they actually hired me to find a case for the church, and we searched high and low, and we found this building that had proper zoning for them to have a place to live.
Thank you. I didn't know your function, so thank you for.
So you had a contractual relationship with the past with the church to act on their behalf? Was it part of your obligation to make the application for the waiver site plan review for the church? And when you went to the Borough of Roselle Park to do this, well, first of all, why did you do it?
Part of my agreement with the church, so we went there, and we talked to Lynn, and we were told that we were okay for a site plan.
Who told you?
For the waiver or the site plan?
The waiver, we were okay, because it was a permitted use, we were okay. And then when we get there, when we got to the building, when we got to the building, and we were sitting in the room for our application, the construction official came in and says, I'm not signing anything, I'm not approving anything. Before anything was even discussed about anything.
Had you filled out this application that people had?
No, the application wasn't even filled out. I had the check with me, money was with me and everything, nothing was filled out, but I had to fill it out even though I was already denied without filling it out. And I had,
So why did you fill out the construction?
Because I wanted it in
That you're
writing.
going to be denied anyway.
I wanted it in writing. I wanted it in writing so we could go through the proper channels to do it right.
So you filled it out?
Correct.
Okay. Now, did the construction official ask you how many square feet of the building you were using?
No.
Did he tell you why he wasn't going to sign it?
No.
Did he tell you about any parking problems?
No. And even the second time when I went with Bill to meet with him again to talk about when we had submitted all the proper paperwork, I recorded the exact conversation. And I asked him several times, and I said, you never asked me for this. She said,
You asked who?
Lynn.
Lynn, okay.
And she says, no, I never asked for any of this information. So in the whole way of going through this, I've been in so many zoning meetings with the state, training a lot of things, that when you do a site plan waiver, you know, it's because it's permitted use, there's nothing changing.
What time?
The orders whatsoever. Parking doesn't matter, whatever the zone for that ordinance for it, that's what stands. So, and I tried to explain it to her, but to no avail, it was denied from day one.
Okay, so we went back on the 11th meeting second. How long after the first application?
For a week later.
And what was produced at that time? Well, I mean,
Well, what we produced to them, we gave them the copy of the lease. We gave them a diagram of the building, how much square footage was used. We gave them whatever information she needed to make a decision, even for a temporary.
She doesn't have the right to make.
Right, I understand that. But, so we try to do as much as possible. And then we so that was basically everything that happened in that time. I even talked to the board secretary several times to get information about the building and moving forward. She's very helpful to help us, get whatever information we need to present to at least get somewhere with this. But I mean, if nothing ever happened, my phone calls stopped getting returned. The board secretary was the only one that would return my calls. I called the construction official. I called the people to return me. No one returned my call. So that's when I went to the last resort to contact Bill and go through court procedures.
I'm very sorry.
It's fine. It's fine.
were you ever told by the construction official why your application was going to be?
No, he never gave me any specific word why it was being denied. He just said, I'm not signing off on anything denied.
And were you ever told by anyone what the parking issues were at the property?
No. No. no one said anything about parking until, we started to go deeper into it. And that was, what was his name? The deputy,
Code enforcement?
code enforcement came in and had a talk. And then he was trying to make decisions on the land. And then once we said that we were going to take the court or do anything down, he pushed back and said, well, I don't have anything to do with this. So then I asked why we're here. What's the purpose of being here in this meeting to discuss this? We have no right to make any decisions. What's the purpose of being here? But then that's when it started going to more about the parking issue. So I said, what's the parking issue? What is the problem with parking? And then previously, to my knowledge, that the building was used as a legal fitness center. And I understand that when you do something that's not part of the lease or part of the zone, that is illegal. That's what it's using. But we went back, the building still stayed in the original zoning, which was a permitted use for church house worship. So moving forward, we said, okay, well, it's still permitted use. So what's the problem? And then they kept saying parking. So then that's when we got the letter X and the diagram about parking, 250 per car. And we supplied that. We gave them a copy of the lease. We gave them everything she needed to make a decision on recycling. And she still nothing.
But that time the decision had already been made, so the next thing would have been to appeal the decision, which is what you've done.
Well, yeah, and at the time, we never got a letter. We presented a letter at the second time we sat down. I asked several times for the letter we just made because we didn't receive a letter at all until like the next week, in which it came with the right correct date and everything, which was fine. But I wanted everything in writing. I didn't accept anything from her that date. I wanted to get it in mail because I wanted to make sure that everything was done correctly and right.
I want to ask Mr. D'Agostino because of something that you had said
Okay,
about
thank you.
prior. Mr. D'Agostino,
Sorry, can I please? Just for the testimony about James Bennett, for the truth and the truth and nothing but the truth.
Yes, sir.
I just need your full name and address.
My name is George D'Agostino. I live at 217 Ave in Roselle Park, New Jersey, for 60 years.
I hear you also go to Florida often.
Well,
You have a tan, don't you?
it's actually fake. But
Oh.
thank you. I've been here because of you very nice people. Thank you.
Oh, yeah.
You want to go back to Florida? No disrespect.
No.
Ma'am, I would like, without even question, straighten just one thing out.
Sure, please do.
You mentioned something, and I'm sorry, maybe they didn't inform me, that for years was a center for family support, that property, maybe close to 20 years. And what they did, it was a center, a community center. They cared for Down syndrome young adults who couldn't afford the proper care. A lot of them were wards of the state. It was a non-profit organization, and they were there pretty much for paying all the time. And that's another story that happened to them.
Thank you.
Same
Thank you for clearing that up. Okay, yeah, I did not know that.
That's what
Yeah.
they were. And when Gene, Fitness for Genie, and I have it right here, where it's another great attorney like in town, North, gave me a letter. I have it right here. We had to show anyone, and I brought it in, and he asked for a waiver of site plan approval because Fitness for Genie was a permitted use at the time. What happened later, when she changed something, I don't know. But it was a permitted use when she went in, and they immediately gave him a waiver. It was right here, and they gave a CO.
No.
Because she was a permitted use. And historically, I'm in that building over 30 years, and no one ever, except for this church, was questioned about parking, and everyone was given a waiver. And the parking's been like that. House studios, if you've been there, forever. And
But
this
the
is first
community
time-
center that was there was Monday through Friday during the day? Is that-
Yeah.
The community center that was there was Monday through Friday during the
Oh,
day?
yeah, they were Monday through Friday, and they would bus, Down syndrome young adults there, and they would care for them all day long. And That's
So
what
they bust them in, so that wasn't where every child was brought in and the car was parked there all day long?
They come in by car also, and they had a staff of about, they must have had 12 technicians. And we go through whatever.
Just like to see the buses that they use in the park at the
Yeah, they park the buses there right at the facility.
in the back on the gravel.
In the back, on the gravel.
Did they ever get a ticket, or were they
Never
ever told
got
that they
ticketed.
couldn't do that?
No, they were never told they couldn't do that, ma'am. And ma'am, I'll blacktop that, and another thing, ma'am, with all due respect, the pipe that goes, I think there is a pipe actually, and it goes through all my neighbor's house. It's not on my property, and I'll be glad to blacktop that. And I'll be glad to do whatever you would like to get these good people before you come in. I mean, please.
And ma'am, I think you made a comment that said that there was a single issue originally to, and you seem to indicate that there wasn't.
No, there was, I know that. But that's why our board exists, is to be able to straighten these things out, because not everybody's perfect, and sometimes COs get, given that are not, shouldn't have been.
And again, I don't think there was ever a decision that the CFO should have been issued originally, but there was a change in use after the CFO was granted, and she started putting exercising equipment in there. And that's when it changed, not when she first moved in there. She was doing a health type of an organization that was actually within the zoning requirement. Mr. Renault made the application, indicated it was a...
I know, but we had testimony and everything, that we need to rehash that.
But the point being that when they did first move in, it wasn't permitted use. It had changed, and that's why they were taken out. So wasn't that they were in there? There were always permitted uses when they went in. The fact that Fitness for Genie changed at some point in time, and I understand what the board did. We all understand what they did. That was something that happened after they were first let in.
I don't have a problem with it. They actually changed their use. They changed their use.
But Mr. D'Agostino and Mr. Courtney, with all due respect, they were a fitness center when they were in Union for years before she came to your building. And then she changed her use when she got there to be a fitness center, so somebody was not doing something right there. So,
Again, Renault, what did you down attorney?
you're not.
No, I'm sorry. I didn't mean to. It's a car. And he brought that in and he made that application.
Yeah, but regardless of what you're saying, I'm just trying to say that.
The point that I'm making, that I'm trying to make, is that any permitted use, there was never a question. They were taken as a permitted use, and I assure you, I didn't try to fool anybody, but they were taken as a permitted use, so therefore, the site plan was automatically waived. They had a site plan waiver. As historically, for the last 30 or 40 years that I've been there, that's what has always happened. I'm not a new kid on the block. I've been here a long time, and I know the problems, and I know a lot of it stems from certain reasons. But I don't want that.
I think we need to get, we're getting,
Okay, that's
thank you, Mr. D'Agostino.
Yes, ma'am. Anything you had a question?
Hello.
At this point, I would really ask that the board consider what's been presented to zoning officer, right? What was presented to her back, the first week of September, on how much space was being utilized. The fact that it's a permitted use is a benefit to the community. All the benefits that it has versus parking. We're talking about trying to utilize a parking with tell a church that they cannot be at this facility. And I understand that they have a parking ordinance. We believe that we need it, but there's also other federal laws that allow churches to be in facilities and prohibit municipalities from enacting zoning ordinances, enforcing zoning ordinances against the church. And again, we have a situation where we're maybe talking about a space or two where cars park on gravel or not, which has been, and there's been cars parking on that gravel, buses parking on that gravel for years. That building has been here for, I believe, over 90 years. Now, before that street was vacated, the only parking it had was the gravel. Right now, we have 7 spots. I mean, over time, the parking has grown here. But if we can't use the parking spaces that we have, the building's worthless. It's 3,100 square feet. It's never going to have the right parking spaces for the 3,100 square feet. My client's trying to lease this building, and he's trying to lease it to a group.
Wait, did you just change hats?
What?
Your client is the church. You said your client's trying to lease the building. You are now talking about a different client?
My client is trying to lease this building for a church.
Okay.
Okay? That's what he's trying to do. Okay? And he wants to utilize that limited space of that building for a church. Okay? And the parking, I mean, you see the photograph, we have 7 cars in there parked. Nothing's over the walkway, it's very orderly. You heard Mr. D'Agostino testify. If this court wants, this board wants to condition.
Thank you, but no.
If you want to condition this on him paving the stones, he'll do it. We'll do it, in the next week. We'll pave it. We'll get the permits and we'll pave it. Okay? That's not going to be a problem. And it'll be in excess of 7 spots if we pave the stones. So we're asking you to look at the reality. To look at this and look at this church and what they're using this building for, and weigh that application, weigh this parking in position on these people. Nobody's really talking. And we've tried to get information since September, and no one tells us what the problem is. Okay? We need to know. And we want to address it, we want to fix it. That's what we want to do. We don't want to be litigated. We just want to fix the problem and let the church get on with it. Thank you.
Thank you, sir. Does anyone have any comments or questions?
Now, how many parishioners do you have in your church? How large is your flock?
We have about 40, actually.
Oh, please speak into the...
I'm sorry.
Thank you.
We have about 40 to 50 members. And actually, not all of them are there every Sunday. As a matter of fact, a good portion of my church is here right now, as you can see before you. And any of them could testify to that as well. We have about 40 members now. Is that the total amount that has ever been a part of our church now?
How much seating have you put in the facility for them? How much seating have you put in? You put pews in there?
No, we didn't put pews, we put individual chairs.
Individual chairs? How many chairs have you put in for these? 50 chairs. And the only time you're going to use the facility is on Sunday morning? You're not going to have evening services or Christmas Eve services?
We will use
For
it
counseling?
as we lease the building. I don't believe there will be any restrictions on our use of the building.
Just a question.
So we have our services on Sunday morning, and at some point, yes, we would like to have a midweek Bible study. We have meetings on occasion there with my staff, which if you need to know numbers on that.
Counselor, how did you propose we split a building? You keep bringing up that you're only going to use half of the building, yet ordinances, to my understanding, and I'm not an attorney, is that you generally or practically you can't split 100,000 square feet warehouse is a 100,000 square foot warehouse. This building is set, this is the size of it, there's egresses back and forth. It's difficult to put an iron gate up there. So how do you propose that the building is split, keeping in mind that if we grant you this, that goes on in perpetuity, that we've now created a different problem for ourselves down the line? So how do we split it?
First of all, there's a
You
firewall.
tear down half?
There's a firewall down the center of the building, okay, and there's doors that shut. They're only leasing one half. It's actually perfectly dividable right down the center of the building, the way it looks. I mean, I think you can't really see it on the diagrams where you're showing the park, but there's a firewall right down that wall, right down the center of the building.
Excuse me, what is the firewall? It's a wall from floor to ceiling.
From floor to ceiling, I believe it's cinder block. Cinder block?
It's cinder block. It's what's required to split a building is a firewall. And it's it may have sometime in the past, it may have been two buildings. If one building is separate, different size roofs, they're sanctioned.
Are there bathrooms on either side?
Ma'am?
Are there bathrooms on either side?
Yes.
Oh, okay.
There's two bathrooms on the side that they're leasing, there's two bathrooms on the other side of the building.
I've never been in the building, so I don't know.
Is it, if I might, is it set up so that another separate tenant doing something else that's a permitted use could lease that other space?
I believe that there's an exit door in the back that could be used for egress or egress out of it, but there's only one door. There'd have to be another door, I believe, put into that building in order to use it separately from the church. I don't believe as it stands now, it could actually be used or leased separately.
Has the space traditionally, Mr. D'Agostino, been leased? Has the space that you're building traditionally been leased to one tenant throughout the years, decades?
Traditionally, as I guess.
Since he owns it.
Since you've owned it? Okay, I just, yeah, okay.
Well, my point was in the past, the way the building goes, you have, it almost looks like two buildings. You might think it works. And there is a firewall, just like a town like you would require if someone wanted to subdivide, or between two spaces in a strip mall. The firewall exists.
But a separate tenant could not currently lease the space that's unleased?
I don't think so, not the way it is.
Okay.
I don't have any desire to.
No, I'm just trying to get a better handle for myself and the board as to what it...
Theoretically, if somebody didn't care about a door into the building from the street, they probably go in the back door, but it's unlikely that would ever happen.
Okay.
Or whether or not it would be up to code to have only one door in that size of space without a second exit.
And we would never know if the church decided to use more of the building, we would never know. They could do that and we would never know.
Well, there were presenters that could not go, and if they did want to lease more of the space, you'd have to lease it from Mr. D'Agostino.
I know, but they're representing today that there's 7 parking spaces, and I have seen it twice with 10 and 11. So I have a problem with this.
Okay. Well, I don't know which days you were talking about. But then do you know that these 7 or 11 cars were coming at this facility for the people there, or were they excess parking from the deli?
They were definitely within the cones.
I understand, but there have been many times that people have the deli would park on that side of the building.
No, sir.
Well, I can answer your question as to where these cars came from. I don't know when it was.
I just need somebody to address that because that's...
He has a picture, ma'am, or the pastor does, of the deli's cars coming.
No, we don't want to talk about the deli. No, it's only about what's on your space.
On our space.
Yes, sir.
Yes, sir.
So, I just wanted to address your comment about no other cars being there. We had a meeting there last week, I believe it was, where while we were in the building, there was an event going on next door, and they had cars or a car to come over and park on our side.
Okay, ma'am, excuse me for just, indulge me just please. I want you to know that I went on a Sunday morning a few Sundays ago, and I sat and I watched. And I want to tell you what I saw. I saw what I felt like were people that I'd like to hang out with. I saw people coming in. I saw everybody being up and friendly. I saw people going into the deli and buying things, and I'm thinking, oh, that's good. And then I saw two, and this has really impressed me, I saw 2 young men who, a man had came out and was telling these young men how the cars were supposed to go. And I watched them, and as the young men were very diligent, and they would go up to the car, and and I watched this, And then the thing that really impressed me was at the end, when everybody's going now in for the services, they put cones across the front so that no more, and at that point, I think there were 7 cars. No more than 7 cars could come in, even though they probably could have fit more, I don't know, you know, but they put the cones, and then these 2 young men had eaten something or something. Well, you know, I mean, they're teenagers, what? Not these young men, they walked all the way over to where the trash was, and they threw the trash. I like sat there and went, man, this is cool. I think this would be really nice if this could work. And then I went Friday night and again Sunday, and I saw the 10 cars, and there was nothing in the other side of the parking lot, so they were all yours, sir, I'm sorry. And then the Sunday, I watched, and I said, oh, why did you do that? Why? And that's what, you know, it's an emotional gut thing to me, but if you're going to be good neighbors, and you know what the restrictions are, why would you not live by them until everything got okay? You know, so you're saying to me that, you know, they're saying that they're representing that they're not going to go on the other side of the building. Yeah, well, do you understand what I'm saying, sir?
We understand what you're saying, but right now, there's no determination as to how many cars can fit in that lot. We believe.
No, by your very paperwork yourself, sir, you say 8.
We say that
you said that we said 8, right?
You say.
So I know, but even so, if you say that, and if you were using that as a representation, even though it's not correct, then why were there more than 8?
Ma'am, again, I wasn't there. I don't know which way you're talking. Again, but what we're looking at is that, you know, if there were more than 7 cars in that lot for 2 hours on a single night, I can't say that there wasn't, but I know that we've seen this over the years. Other places, other establishments in that area tend to pack as many cars as they can up in their lot. They don't park in lines. They stick them all in there, and there's never a problem with that. These people, and I would imagine that when you saw those more than 7 spots, nobody was on that parkway. Nobody was blocking that.
Correct.
Okay? They managed to get those cars in there and still have that walkway totally clear.
They had them in the back on the gravel.
Right.
Yeah.
But nobody was being prevented from walking down to that tunnel, and they made sure that nothing was preventing egress to that tunnel, which was a very, very important requirement of the Township of Roselle Park, and they know that they're not supposed to block that walkway. And whether or not it was 8 cars, or at this point, we don't know how many cars technically should be on that. We think we could put more in. The town says 8. We say more. And the court didn't tell us how many cars we could park or not park there while we were in this. And if this board tells us we only can have 7 cars, that's how many cars we're going to have.
And this board has asked you to show us where those cars will be in accordance with our ordinance, and you have not provided that.
And, well, again, you're asking me that right now. No one's ever asked me that before. And again, and I have to know the ordinance again that you're saying that says that.
Look, the whole part of when someone seeks a waiver from a site plan approval for parking issues, as we have here, you know, I think the zoning officer, it's not the town's burden of proof to establish that a waiver can be granted. In order for a waiver to be granted, the zoning officer would need to be provided with a site plan that shows the number of spaces that can be on that site. The board cannot rely on the planner's statement and on the related application that 8 are there. That's not established as a matter of fact. That's the applicant's burden. That was the applicant's burden before the zoning officer. The zoning office, or I should say the ordinance, is 48-203, where section T, which talks about, you know, depending on how the parking aisles or spaces are angled, there's going to be different requirements for the footage of a 1-foot aisle, for the dimensions of the spaces. So the zoning officer, as far as I understand, did not have before her that kind of information that would show a site plan with the number of spaces that can be accommodated on that site pursuant to the ordinance, and depending on how they're going to angle them. That's the primary issue here.
We did, first of all, when we filled out the waiver for site plan, Zoe said she wanted to see a site plan for parking. We only found out that parking was an issue when we got the letter saying you're denied because you don't have adequate parking. So there was no opportunity before we were denied to say, well, we do have any parking, because we didn't know it was an issue until it was denied. So there's a problem there. The second issue is when you look to Ordinance 103, Section 4701, approval by a certain board required. Section C says the construction code officials may waive site plan and approval for alteration of existing buildings. And this is the wording. When the alteration will not change the exterior of the building, the use is permitted in the zone district, the alterations will not increase the parking. There's no, when we're looking at the waiver site plan, there was nothing in this ordinance that said that we need to submit a parking plan.
No, this reminds me of the ignorance of the law is no excuse kind of phrase. I mean, our ordinances are our laws, and not knowing our laws, unfortunately, has gotten you into this predicament. But knowing what they are now, and saying that you would like to abide by them, is a very positive thing. It's just not going. It may have to go through a few stages. Now, I don't know how the board is going to vote. I don't know. I just know what my feelings are. But I tend to think that in order to come into a new place and be a good neighbor, it's in your best interests to try to say, okay, maybe we didn't know, but we will, and we'll follow the way that it's supposed to go. And you didn't do that. You went to court, and you got a temporary CO, and now we're all nervous because, well, I'm nervous because you're in there, and we don't know if it's safe for you to be in there because we don't know what was left behind when the person left before, and it's some issues.
Well, as far as us not abiding by the law, it's your position that we didn't abide by 48203T. Is that the law we didn't abide by?
Yes.
Okay. Any other ones?
Well, whatever you may find, but that, to me, that strikes me as the most important one.
That wasn't cited by the zone.
X. X and Y and Z.
Says right on here, it's X.
And I'm sorry, X is which talks about the one spot per 250 square feet of floor area.
But basically, I'm just going to summarize this, and because you made excellent points. But basically, what it is there was a waiver for site plan review for a change of tenancy. The use is approved. As a board, we try very hard to make everything fair. We do not try to give anyone less treatment or better treatment than anyone else. So in this case, we just, like we would have anybody else, followed our ordinances and our zoning officers' denial. So now you then have the opportunity to say, okay, we appeal this, and we are at that point right now. Now, if I want to just go through the two possibilities or more, I may be wrong, but we now take a vote. We can still discuss this a little more, but we take a vote. If the board votes to uphold our zoning officer, then you have options that you have to then decide what to do about. If we decide that the zoning official wasn't wrong to deny your waiver, then you are able to.
If the board upholds the zoning officer's decision, the applicant has some options. They could return to the zoning officer with a site plan that reflects how, first of all, number one, the number of spots that are required on that site per the ordinance we've discussed. You cannot simply rely on what the planner said in a non-related application with no backup at that time. And then secondly, in that submission to the zoning officer, you would show how those spots would be accommodated on that site. With that information before the zoning officer, in my view, she could then make a determination as to whether site plan could be waived or not. Your other alternative, I suppose, would simply be to seek a variance for parking issues. I also want to say that it is not terribly uncommon that when one permitted use is exchanged for another, that zoning officers and boards in fact require site plan approval just because of the fact that the intensity of one permitted use may be much greater than the intensity of a prior use, and that raises issues of not just parking spaces but circulation on the site and other issues. So the fact that this is a permitted use does not somehow obviate the need to deal with the parking issue, parking space issue. So, but those are the two options that I would think that the board has, that the applicant has, should the zoning officer's decision be upheld. If the zoning officer's decision is reversed, then this board would basically direct her to issue a waiver of site plan for this applicant.
Does
Now,
that sound?
I understand what you're saying. I just want to know, just for my own purpose, I know you're making, considering different things in this application, and whether or not the zoning officer of this board did look to the Religious Land Use and Institutionalized Persons Act, and it's 42 U.S.C. 2000 CC, in making the determination and trying to determine whether or not the implementation of this land use regulation imposed a substantial burden on the rights of a religious assembly. That's something that I need to know whether or not did consider or didn't consider in granting or affirming or denying or reversing zoning officer's application.
Okay, I will let somebody else speak while I look up, because I did. So let me find.
Well, I think the board's entitled to take a vote regardless of whether every single person looked at that law or not. That's not really, you know.
My point
Yeah.
is,
The chairman's told you that she has looked at it.
well, the issue was that there were certain things that were considered. I didn't know if that was one.
That was certainly one of the things considered, yes.
Yes. All right, I'm going to pull it, and because I have it. And if anybody wants to see it, now what specifically were you referring to, Mr. Courtney, in the?
Whether or not the implementation of these zoning regulations places substantial burden on the right of the religious assembly.
And here's why I say no. Okay. I say no because under the paragraph where it says minor costs or inconveniences posed on religious institutions are insufficient to trigger RLUIPA's protections. The burden must be substantial. And likewise, once the institution has shown a substantial burden on its religious exercise, the government must show not merely that it has a rational reason for imposing the restriction, but must show that the reason is compelling. It is not any different than what you're going through right now. Isn't any different than if there was some other use in that building. And I'm going to finish, okay? And then you can say what you want. But okay, so then because I really feel strongly about treating people equally, and I really feel that I would love to treat you better than everybody else because the use that you are coming into our town with is one I highly approve of. But I can't. I have to treat you equal to everybody else, not people less and you more. Please understand that. So then the second thing is religious institutions must be treated as well as comparable secular institutions. Section 2B1 of RLUIPA provides that religious assemblies and institutions must be treated at least as well as non-religious assemblies and institutions. This is known as the equal terms provision. And that is why I feel I have considered this, and I feel that we are treating you very fairly.
Again, if you're going to be at least as well as the other uses, this is why we tried to bring up the neighboring uses, but we were prohibited from doing that because we do feel that we were treated differently than the neighboring uses. Again, the properties on either side of this piece were treated in a certain way and are misusing their parking, and nothing is being done. That was what we were going to
Yes,
present.
sir, you are right.
And this is part of the reason we wanted to present that, because this, we do believe is acts of clause. The other thing is, can we get from the board, or from the borough, what the compelling reason is, not just the...
No, that's for you to tell us. The compelling, I do not think there is a compelling reason.
Why the zoning ordinances need to be enforced.
But may I ask, is it your position that the zoning ordinances are completely irrelevant because this is a religious purpose? Is that what you're saying?
I'm not saying relevance is not the issue in the statute.
Well, I'm asking...
There's a difference in the standard
Right.
that a governing body has to meet when you're talking about a constitutionally protected right, which is the right to religious affiliation and to practice a religion.
I understand.
There has to be a compelling reason to implement the zoning ordinance. And if we don't know, well...
That's not what this says.
Well,
I don't think we need to get into an argument back and forth with the council and chair.
I just needed to know if there is good company.
And I told you my reasons, and I also want to address what you just said about the other people, because yes, we did not want to get into deep discussion about that, but yes, if you think that they are being treated differently, it may very well be that they are, but we are not hearing that now. In other words, 20 years ago, or whatever, how many years ago that the ballroom got their waiver of site plan review, or their site plan, or whatever was in front of this board, those issues were addressed. And however they were answered, they were answered. Now, if they're not living up to what they're supposed to be, it's not this board that is the one that's supposed to be their policeman. We are not, that's not our function. And the same with the deli next door. If what happened many, many years ago with them, whatever the results of that, that is an entirely separate issue, even though you're right, there may be different treatment. But that's not for us on this board. We are simply trying to get you into the building in the correct way. That's all.
And I do want to, and this is the last thing, is I want to emphasize to this board that the Heart of Worship Church wants to, with all of the regulations that you have, they want to be a good citizen here of Roselle Park. But they do want to keep their doors open. They've been trying for years to find a home, and they found a home here, and they want to stay here. And they're doing, and they're going to do a lot for this. I just want to sum up that the pastor talked about a 40-person flock. Once he gets this church established, he's not going to, right now he has one service on Sunday, he'd like to have 3 or 4. And that 40-person, maybe he'll have 10 on each one. It's not going to be this massive group of people that come in here during the day, the people that are working with him and trying to reach community reach-out services and to help the community members. They're going to be there, but it's not going to be a monster. They're going to try to do good for the community. And they really want to comply. They don't want to be in an argument. They don't want to have to go to court for these things. But they have to keep their door open, because if they shut that door, they're going to lose their flocks. It's going to impact their religious services and the people from the church there.
Pastor, may I ask you a question? If this does go your way, and you are able to have 7 parking spaces, and as I have seen myself, you do abide by that, you can, what happens when now you forget, and it's 8 cars, or 9 cars, or 10 cars, and the next thing you know, you're getting a summons, and now are we going to say, oh, we're keeping you from religious expression or whatever, because we are giving you summonses because you have, I have a problem with that, so I want to hear from you that if you abide by our rules, you will abide by our rules. That's what I want to know, because
I'm going to direct you not to answer that question, because we weren't allowed to discuss how the law is being enforced in the neighboring properties. And I would believe that if this board is going to say that you're going to enforce that if you have 7 spots in your lot, 1 car over, you're going to get a ticket, and that's enforced everywhere in Roselle Park, I don't think that we would have a problem with that. But that is not what's happening. And that's a problem, so we can't answer that question.
the way it's phrased.
Fair enough. I still would like a parking plan. So based on the information that we have, we do not have a specific parking.
Can you just give me a second?
Of course. Oh, Mr. Courtney, would it be all right with you if we took a 5-minute break?
Sure.
That'd be great, thank you.
All right. We have heard our zoning officer, we have heard the applicant's attorney. And I'm going to let our yes, sir. Did you have anything else that you wanted to say?
I'm sorry, I was, no.
Okay, and now I'm going to ask our attorney to word what a motion would be so that we can understand what we're actually voting on.
Yeah, before I do that, is there any further discussion on the board? Okay. The motion, I think the motion should be whether to uphold the zoning officer's decision on this appeal. So if you vote yes, you're upholding her decision. If you vote no, you're reversing her decision. And the question before you really is whether with the information before her, or the lack of information before her, she made the correct decision. That's really all this is about. And if you vote to uphold her decision, the applicant has options, which could be A, as I think I mentioned before, to return to the zoning officer with a current site plan reflecting the number of spots that belong on the site and how they would be configured on the site in accordance with 40-2803T in particular, as well as other portions of that ordinance. The applicant could also simply choose to seek a variance, but I would think that the first option might make more sense depending on what the board does. If the board votes to reverse the zoning officer's decision, that would mean it would then need to direct the zoning officer to issue a waiver of site plan.
Is there someone who will make a motion? Do you need him to?
Okay, you can either make a motion to uphold the zoning officer's decision or a motion to reverse the zoning officer's decision.
And make a motion to uphold her decision.
Is there a second?
Second.
Is there any discussion? All right, we will now take a vote. Will the Madam Clerk please call the roll?
So a yes vote is to uphold the zoning officer's decision. A no vote is to reverse it.
Mr. Nucci?
Yes.
Mrs. Kurz?
Yes.
Mr. Stevens?
Yes.
Mr. Costello?
Yes.
Mr. Nichol?
Yes.
Mr. Robina?
No.
Mr. Bayamonte?
Yes.
That is the decision of this board, and we are upholding our zoning officer's denial of the waiver. And we wish you a lot of luck. Thank you very much.
Is there any way that we can make a conversion application for a temporary CO for this until we make the next application? Because if not, we have to go back and forth.
I think you have to have, to get a temporary CO in our town, there are a few requirements that you have to meet, and I would
We really can't, as I think you probably know, we can't issue a temporary
ask you to go to our
I mean, the question, you could deal with the zoning officer or the building department as to this interim period of time where you have this decision and presumably additional action you're going to take. But, I mean, we can't issue a temporary certificate. We don't have that, the board does not have that authority.
Thank you. All right, we have more business. To finish the meeting for tonight, pending resolutions, there are none. Payment of bills, there are none. And our next public meeting will be November 3rd, on Monday, at 7 o'clock. November 3rd. I guess that was arranged early in the year, for some reason, I don't know why, but that's what it is. Carol, when is the December meeting? So the next two meetings until the rest of the year is December 15th, and the next one is November 3rd. Oh, the picture? And, let's see. Just want to see, is there anything for the benefit of the board? I had something, I can't find it. So, do you know what that means? It waits until November. Is there anyone wishing to make a motion to adjourn?
Second.
All those in favor? Aye.